I respectfully move the verified impeachment complaint against Vice President Sara Duterte be dismissed.
Mr. President, momentarily suspend any action. I still
Point
have
of
the floor.
order.
I have the floor, Mr.
Point of
President.
order.
I have the floor, Mr. President.
We have no constitutional authority as legislative body to dismiss an impeachment complaint.
Senator Bato is not an attorney, but he's talking like an attorney. So, Senator Batorni. Mr. President,
Senator Cayetano is recognized.
with the permission of the Majority Leader and Senator Bato, the Minority Leader, may I just offer some voice of experience. Actually, sinabi na to ni SP, pero I'll just elaborate. But let me start out by saying, I understand why the Minority Leader stood up. Yes, minority at mas konti sila, but they have a role to play. It's not only a very important role today, it's an essential role. It's not only a role in our legislative session, it's a role in holding the second highest person in our government accountable. They have fought for that not just yesterday, but the Minority Leader, despite running for Congress, have continued, in Tagalog, tinutukan to. And in fact, I have to apologize to him, medyo mas tama ka na yung forthwith means agad, pero tinignan ko na yung Filipino version, isusunod agad. In that context, makikiusap ako sa Minority Leader. We've been here long enough, dun sa atin na 3-4 terms na pag nag-argue ko sinong una, tatagal tayo na 1-2 oras, walang mauuna. So kung gagawin natin yung forthwith today, ibig sabihin isusunod agad. I looked at the rules, no? Sabi po kasi talaga pagka personal privilege, pwede mauna. But ang sabi nga ni Minority Leader and backed up by the Deputy Minority Leader, we know how important the impeachment court is. So may I ask a further favor indulgence from the Minority Leader that we allow Senator Bato so that we also do not violate. We're going to violate 1 or 2 things today. Violate the agenda, dahil sa agenda talaga mag-oath taking, or violate our rules, dahil sabi sa rules, anytime pwede kang tumayo sa personal privilege. So may we ask for the indulgence ng minority to allow Senator Bato to deliver his speech because binanggit niya to sa aking kahapon. Kung ako nagkulang, pasensya na po kayo dahil ang pakiusap niya kahapon, bago mag-oath, magsasalita siya. So if we can allow him, then with the permission of the Majority Leader, I'll volunteer you to forthwith immediately, agad-agad move na we take our oath as members of the impeachment court, if it's acceptable to the Minority Leader. It's not the perfect solution, sir, but I hope it's acceptable.
What does the Minority Leader say?
Basically, Mr. President, we will agree to the suggestion of Senator Alan Cayetano. Pero ito lang yung point ko for those of you still present or serving in the 20th Congress. There is a purpose, meron tayong agenda. So when you are in number 7 for privileged speech, you cannot just stand up and then accelerate the tackling of your item in the session, Mr. President, by just standing up. So ano lang po yun, just an observation. So with that, I willingly give way to our colleague with this important message for us, Mr. President, Senator Bato Dela Rosa.
We thank Senator Pimentel, also thank Senator Cayetano. Sana mas madalas-dalas siya dito. Hindi ikaw kokoha, si Alan. And also for the record, I'd like to assure our Minority Floor Leader and Deputy Minority Floor Leader that we will, the chair would rather preside over the oath-taking of members of the impeachment court today. Before we adjourn, the clock not with standing to give way to the privileged speech of the Honorable De La Rosa, because the Senate, after all, is a deliberative body. Everyone should be free to say their piece, subject to certain limitations, of course. And we are free to agree or disagree. And if the matter cannot be settled, for it to be put to a vote. If there are no other members who wish to state their piece on the matter, Chair now recognizes Senator Bato Dela Rosa. You may proceed, sir.
Thank you, Mr. President. Mr. President, esteemed colleagues, ladies and gentlemen, imagine a house, Mr. President, an unfinished one that is still being built. Where do we begin? Of course, with solid foundations, a level ground, as well as an honest blueprint. Hindi pwede ang mga shortcut. Hindi pwedeng madaliin. Kung babaliwalain ng mga architects at mga engineers ang mga basic requirements, hindi magiging matibay ang itatayong bahay. Maaari itong magdulot ng panganib, hindi lamang sa mga maninirahan dito, kundi maging sa ibang mga kabahayan sa paligid nito. If any of us happen to discover that the house we were living in was structurally unsound, we would likely scramble to have it retrofitted. We would probably file cases in anger against developers. I doubt any of us would simply shrug our shoulders, saying, andito na tayo hayaan na lang. Now, imagine a house of representatives that built and filed the impeachment complaints against Vice President Sara Duterte. Trabahong inupuan sa simula. At noong papalapit na ang deadline, biglang naging buzzer beater. Mabilisang pinasa sa atin at ngayon tayo naman ang pinipilit at minamadali. Pinapagalitan pa nga, that is your sworn duty. Tama na ang pamumulutika. This is undue delay. Sandali. Bakit kaya sa pagkakataon at pangyayaring ito, tila madali lang para sa atin ang sabihin, andito na tayo Andyan na nga Mr. President, the House of Representatives are of the belief that they have built a solid case against Vice President Sara Duterte, prompting them to file an impeachment case. But how sound are the foundations of this impeachment case filed against the Vice President? Kagaya po ng konstruksyon ng isang bahay, ang proseso ng impeachment ay kinakailangan na nakatungtong sa isang solidong pundasyon. Ibig sabihin, ang mga arkitekto na pasimuno nito ay may tungkulin na tiyakin na may tatayuan ang kanilang mga akusasyon. Ngunit, ang impeachment ay isang proseso na hindi nakasalalay lamang sa mga arkitekto o mga instigador nito. Sa totoo lang, pinakamadali ang naging gampanin ng HOR sa proseso ng impeachment. Yun ay ang pagbubuo ng mga akusasyon, Mr. President, kahit sino po ay maaring magparatang kung kanino man. Sa bahagi naman po natin, ang pinakamahirap, ang paghusga, ang paggawad ng isang hatol na makatarungan at katanggap-tanggap. Anuman ang nakatuntong sa mahinang pundasyon ay laging may panganib na gumuho. Kung ang isang impeachment case ay minadali at nakasandig sa paghihiganti at pamumulitika, ay maihalin tulad sa isang estrukturang itinayo sa gilid ng bangin. Bagamat tungkulin o obligasyon natin sa Senado na mag-convene bilang impeachment court, responsibilidad din natin na maging mapanuri at critical sa impeachment complaint na ipinasa rito sa ating bulwagan. As I usher in my 6th year in the Senate, my 39th year in public service, Mr. President, I can say I have gotten better at spotting irony. What we refuse to let happen to our houses, we seem to have allowed our House of Representatives to do in broad daylight, right under our noses, and at the expense of our institution's esteemed reputation. With this, Mr. President, my dear colleagues, allow me to express my serious concerns surrounding the constitutionally unsound foundation of the articles of impeachment that the Senate is set to tackle. Article 11, Section 3, Paragraph 2 of the 1987 Philippine Constitution provides that a verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. Keeping in mind the aforementioned constitutional provision, recall that on December 2, 2024, the first impeachment complaint against Vice President Duterte was filed before the Secretary General of the House of Representatives. The second and third impeachment complaints were filed on December 4, 2024 and December 19, 2024, respectively. These complaints were each endorsed by members of the House of Representatives. While the Constitution requires that a complaint for impeachment must be included in the order of business within 10 session days, the House of Representatives rules of procedure in impeachment proceedings require the Secretary General to immediately refer the complaints to the Speaker. Despite this, no action was ever taken by the House on the 3 impeachment complaints filed. Hindi po ito simpleng pagkalimot, Mr. President. Ito po ay tahasang pagsantabi ng kanilang internal rules at constitutional provision. Sinadya po nila na baliwalain ang konstitusyon. Maliwanag po ito sa mga naging panayam kay House Secretary General Velasco. In media interviews, the Secretary General publicly disclosed that the members of the majority of the House of Representatives asked him to withhold the transmittal of the impeachment complaints to the Speaker. Their goal then was to give themselves more time to decide whether or not to file another impeachment complaint. Pinaghintay po ng mayorya ng House of Representatives ang 3 impeachment complaint. May ganyan po ba silang kapangyarihan? Tila po, ito ay matatawag na grave abuse of discretion. Then, on February 5, 2025, more than 2 months after the first impeachment complaint was filed, the House of Representatives took the express, the fast-track route according to Secretary General Velasco. Kung ang 3 naunang impeachment complaint ay pinadaan sa EDSA, mukhang sa Skyway po ang piniling landas ng House para sa pang-4 na impeachment complaint para maiuwi ito sa Senado. With less than an hour before the close of session of that day, the House of Representatives transmitted to the Senate a verified complaint for impeachment against Vice President Sara Duterte, purportedly signed by 215 members of the House of Representatives. My honored colleagues, had the House complied with their own rules and the Constitution, the 3 previous impeachment complaints would have been referred to the appropriate committee by the time the present impeachment complaint was filed and sponsored by the members of the House of Representatives. In other words, Your Honors, the intentional inaction of the House of Representatives allowed its members to purportedly circumvent the 1-year ban enshrined in Article 11, Section 3, Paragraph 5 of the Constitution. Given the glaring circumvention of the Constitution, should we allow impeachment complaints which are constitutionally infirm to be heard and tried by this body? Kung defective po ang foundation ng impeachment complaint, marirepair o marirehabilitate ba ito ng pag-convene ng impeachment court? Hindi po ba mawawala ng saysay ang pag-convene ng Senate as an impeachment court kung malinaw na labag sa konstitusyon ang nais nating itayo? Kaya ang impeachment ay isang sensitibong proseso. Sa pagsampa pa lamang nito, binabato na agad ang akusado ng putik na kahit maakwit ay tila habang buhay ng nakamansa sa kanyang pagkatao. Pagkatapos ng impeachment, anuman ang magiging hatol, the damage done to the reputation of the accused will forever be irreparable. He or she will never be the same again. Some of the members of this august body may not agree with me and may take a different view as to whether the 1-year ban has been violated by the House of Representatives. To settle this issue, the separate opinion of Chief Justice Renato Ispuno in Francisco versus House of Representatives provides this body a direction on the course of action that we may take when confronted with the same issue I laid down. Former Chief Justice Puno said that before the Senate is convened as an impeachment court, the Senate, which has primary jurisdiction over the case, can already decide the question on whether the 1-year ban has been violated or not. That is why, insisting ako na ma-deliver ito before we convene as an impeachment court. Hindi po natin kailangang hintayin magbagong anyo ang Senado at maging isang ganap na impeachment court. Ngayon pa lamang ay maaari na nating pagdesisyonan ito. Sumunod ba sa saligang batas at sa internal rules ng mababang kapulungan ang impeachment complaint na kanilang ipinasa dito sa Senado? Nasa Senado po ang pagkakataon upang magwasto. Kung minadali ng isuar ang impeachment complaint, bakit kailangan natin itong tumbasan ng kaparihong kawalang pagpapahalaga sa tamang proseso? Madalas po natin sabihin, dito sa ating kapulungan, we are men and women of rules. Manatili po tayong ganon, malayo mula sa ingay at impluensya ng kung sino mang may mga personal na interes at pakinabang sa pagmamadaling ipinipilit sa atin. Mr. President, the inaction of the House of Representatives resulted not only in a possible violation of the Constitution, but in another justiciable controversy. It is worthy to note that its new Congress, empowered by a fresh electoral mandate in both the House of Representatives and the Senate, is not bound by the legislative actions of its predecessors. Hindi po natin maaring pilitin ang mga papalit sa atin sa future Congresses na ipagpatuloy ang anumang ating nasimulan. Sabi nga po ni President Chis Escudero kahapon, the Congress cannot pass an irrepealable law. Lahat ay pwedeng baguhin at galawin ng mga sumusunod na mahahalal sa Kongreso. Maari pong hindi sila gumalaw at hayaan lamang na nakatiwangwang ang anumang proceeding na sinisimulan ng mga nauna. When the fourth impeachment complaint was submitted, the 19th Congress was teetering on the brink of a long slumber. The Senate is now being urged to convene with only 2 session days, 20 days remaining before the 19th Congress closes. Hindi man po ako abogado, alam ko pong walang kaso, mapasibil, administrative, o kriminal na dinidinig sa loob lamang ng isang buwan. Naghihingalo na po ang buhay ng 19th Congress. Bakit po natin ipipilit pa kung ang pintuan ng 20th Congress ay malapit nang magbukas? Malinaw naman po sa ating Rules of Procedure on Impeachment Trials, kailangang isumon ang person impeached para paharapin sa Senado. Kailangan din siyang bigyan ng 10 araw para mag-submit ng kanyang answer. 5 araw naman ang ibinibigay sa mga prosecutor para mag-file ng kanilang reply. Kaya po, kahit mag-convene ng impeachment court, bukas, summon at pagtanggap lamang sa pleadings ang kayang magawa ng 19th Congress. Sigurado na po tayo na ang trial kasama ang pagrepresenta ng ebidensya ay magaganap sa 20th Congress, kung saan bago na po ang komposisyon ng Senado at mababang kapuluan. Because of the change in members, questions are being raised on the jurisdiction of the 20th Congress to carry on with an impeachment trial commenced in the previous Congress. Should the 19th Congress convene an impeachment court, what assurance exists that the 20th Congress would continue the trial? Without such assurance, any efforts by the 19th Congress would constitute a significant waste of government resources. Even the authority of the House of Representatives to continue prosecuting is being questioned since the said complaint was filed by a House of a different composition. In fact, some of those who signed the complaint failed to secure a seat in Congress in the recently concluded elections. Mukhang kailangan po natin ng positive act from the 20th Congress House of Representatives na kanilang itutuloy ang impeachment complaint na ginawa ng 19th Congress House of Representatives. Mr. President, the constitutionally given power and mandate of the Senate to try and decide all cases of impeachment is an immense responsibility that must be exercised in good faith, with sincere intention to fulfill a solemn oath, not with haste, but with careful circumspection, mindful of both the political and legal nature of the exercise. Ang impeachment ay isang proseso na hindi lamang mag-aalis sa pwesto ng isang mataas na opisyal ng pamahalaan. Ito ay isang armas laban sa sinuman na hindi umaayon sa kagustuhan at mga interes ng mga kaaway sa politika. Ito ay apoy na hindi lamang nakapapasok, kundi may kakayahan na tupukin at sunugin hindi lamang ang isang bahay, kundi isang buong komunidad. Mapanganib ang impeachment sa kamay ng mga mapagsamantala. Inilalagay ang impeachment para protektahan ang taong bayan, hindi isakdal at hiyain ang kumakatawan sa kanila. In the 2012 case of Chief Justice Renato C. Corona versus Senate of the Philippines, the Supreme Court declared impeachment, described as the most formidable weapon in the arsenal of democracy, was foreseen as creating divisions, partialities, and enmities, or highlighting pre-existing factions with the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. The House of Representatives, in transmitting the articles of impeachment to the Senate at the last hour and after refusing to act for over 2 months on 3 previously filed complaints pending with the House Secretary General, has instead placed the Senate in a tight and impaired position where any decision, action, or inaction on its part will be put into question. An acquittal, conviction, or even the propriety of proceeding with trial will be hounded not only by legal or constitutional questions, but by accusations of extreme bias, partiality, and lack of sufficient deliberation. Lagi kong sinasabi, Mr. President, hindi ako abogado. Nevertheless, this cannot disqualify me from speaking against possible constitutional blunders. Hindi kailangan maging engineer para masabi ng isang tao na unlivable at hindi ligtas ang isang bahay o building. Alam nyo, alam natin, kung kailan matibay at pulido ang pagkakagawa, katulad ng isang bahay na bato. Alam din natin kung kailan hindi. When the floor starts to crack, when the walls begin to shift, and when leaks appear where there should be none, there and then, Mr. President, there and then, forthwith, we say, this was not built well. Gayon din sana sa impeachment case na ito, the cracks and holes have begun to show. Alam nating may mga tanong na hindi pa nasasagot, lalo na patungkol sa constitutional soundness ng nasabing impeachment complaint. It is my humble opinion then, Mr. President, that with this knowledge must come swift and intelligent action. Kung gaano natin kabilis i-condemn at ipagiba ang mga strukturang hindi ginawa ng maayos, ganon din dapat tayo kabilis umaksyon kung ang nalalagay sa alanganin ay ang ating konstitusyon. In the spirit of true action, therefore, allow me to end by moving. I respectfully move that in view of its constitutional infirmities and questions on the jurisdiction and authority of the 20th Congress, the verified impeachment complaint against Vice President Sara Duterte be dismissed. Mr. President, since I have still the floor, I would like to call Senator Bongo. Mr. President.
Mr. President, will the good gentleman yield the floor for a few remarks as part of the privilege are availed by Senator Dela Rosa.
Yes, Mr. President, no problem with me. Thank you, Mr. President.
Mr. President, litis na ito
Senator
ay
Go,
hustisya.
Senator Go, before you proceed, Chair has not yet recognized you. Chair would like to first state the parliamentary situation. After the privileged speech of the Honorable Bato, he asked that the chair recognize Senator Bongo to deliver a seconding speech to the motion he made at the end of his privileged speech. The chair has not yet acted on that motion and has not yet recognized Senator Go. And before the chair declared a short suspension, two members raised their hand to be acknowledged and be heard, and the chair intends to listen to them first before acting on the pending motion. Senator Ontiveros first, and then Senator Villanueva. You may proceed, ma'am.
Maraming salamat po, Mr. President. Immediately after the speech of the good gentleman from Davao, I move that any interpellation or any action, any seconding speech was the subject of the approved motion yesterday, and again, the subject, which was the subject of the approved motion yesterday, which is an offshoot. I have the floor, Mr. President,
A point
to
of
make
order,
way
Mr. President.
for
Session-
taking of the
session
oath
is
before the
suspended.
presiding officer.
What is the point of order of Senator Marcos?
Yes, thank you very much, Mr. President. And I'd just like to reiterate that I wasn't being rude, but simply recognizing the fact that the point of order takes precedence over all other motions. Also, that there is, in fact, a motion already pending on the floor, already acknowledged as well by our majority leader, which requires a vote.
Duly noted, but the chair has not yet acted on the motion and there has been no objection as of yet. We will address the motion of Senator Bato, as the chair said earlier, after we hear from Senator Villanueva now.
With all due respect, Senate President, the Deputy Minority Leader is proposing yet another motion on top of the pending motion.
The chair
That
will
is
not-
not allowed.
The chair has not yet acted on that motion and will not yet so act on that motion. And will be making a ruling after we hear from all of those who raised their hands earlier. So, with the indulgence of Senator Marcos, can we hear from Senator Villanueva?
Thank you very
And then
much.
the chair will rule on the pending matters. Senator Villanueva is recognized.
Thank you very much, Mr. President, distinguished colleagues. Mr. President, if I hear it right, the movant made a motion to dismiss the impeachment complaint, if I heard it right, Mr. President. Mr. President, may I just place on record that this representation respectfully object to that motion. Mr. President, for various reasons, Mr. President, that this representation would like to raise on the floor, Mr. President. One, Mr. President, is that the Senate, as a legislative body, and at this point in time, we have not yet convened, Mr. President, as an impeachment court. And therefore, Mr. President, this representation believes that we have no constitutional authority as legislative body to dismiss an impeachment complaint. Let me quote the Constitution under Article 11, Section 3, Number 6 of the 87 Constitution. The Senate's role is expressly limited to trying and deciding all cases of impeachment after the House of Representatives has transmitted a valid articles of impeachment. Mr. President, the Senate, in its capacity as a legislative body, does not possess the constitutional authority to unilaterally dismiss an impeachment complaint. And under the constitutional framework, the Senate assumes a distinct and separate function when acting an impeachment court. Please don't get me wrong, Mr. President. In fact, a lot of the statements made by Senator Bato Dela Rosa, I share. I shared the sentiments, Mr. President. In fact, Mr. President, when the impeachment case was filed, or the articles of impeachment were transmitted here in the Senate, an hour before we adjourned, Mr. President, before our break, a week after, more than 400 380 pages, Mr. President, of annexes ang dumating po, Mr. President. So, dun pa lang, Mr. President, I agree with Senator Bato's statement na somehow minadali or tignan natin. But again, Mr. President, my only concern here is that we have not yet convened as an impeachment court. We can probably dismiss this or even entertain the motion if we are already acting as an impeachment court. Let me go to my other point, Mr. President. The Senate lacks the power to dismiss an impeachment complaint and has no constitutional duty to proceed to trial. And that's why, Mr. President, if you recall yesterday, this representation mentioned that notices are very important when the minority leader made a motion yesterday that he wanted to stop our legislative work and proceed with the convening of the impeachment court. And he made mention about the calendar of activities, kung kailan magsisimula, ano yung timelines, etc., Mr. President. And that's why I objected again, Mr. President. So in the name of consistency, Mr. President, let me again state for the record, the power of initial determination belongs solely to the House of Representatives. You and I, Mr. President, were members of the House for quite a long time. And we talk about it all the time, that it is the sole power of the House to determine kung yung impeachment or articles of impeachment na itatransmit sa Senado ay merong required votes, etc., etc., at ang tanging sole authority naman ng Senado is to act as an impeachment court, not, Mr. President, not as a gatekeeper of the complaint's sufficiency. Further, Mr. President, it bears emphasis that the framers of the Constitution intended a clear division of roles. House initiates and the Senate tries and decides. Again, Mr. President, I am not even going to say whether or not I will support the motion of our dear colleague, Senator Bato Dela Rosa. I'm just saying, Mr. President, that it should be posed, Mr. President, in the impeachment court. Last but not the least, Mr. President, the Senate as a legislative body, or even when it sits as an impeachment court, Mr. President, ito po yung ating posisyon, may not dismiss the impeachment complaint due to change of Congress. Impeachment, Mr. President, is a political discretion. It's not a political discretion, but a constitutional mechanism rooted in the principle that public office is a public trust. Alam na po natin lahat yan bilang mga lingkod bayan. Yung sinasaad ng 87 Constitution, which provides public office, is a public trust. Public officers and employees must at all times be accountable to the people. This duty, Mr. President, is not suspended, nullified, or extinguished by the expiration of the legislative calendar or the transition to a new Congress. But again, I also believe and support the statements made a while ago by Senator Bato Dela Rosa. Yung pong functus officius ng Senado, hindi ho applicable sa atin dahil kalahati nga ho sa atin dito, magiging parte pa rin ng impeachment court, parte pa rin ng Senado. Pero doon po sa House, hindi na. So kailangan talaga na malaman natin kung sila'y interesado pa doon sa impeachment na kanilang i-final. Mr. President, just this morning, if I don't know if this morning or last night, I saw an article. I'm not sure if it's Justice Ascuna or Attorney Divina saying that the House must actually do something, whether at least, the very least, is to pass a resolution authorizing, Mr. President, their representatives, their prosecutors, that they are indeed have the blessing of the 20th Congress. Kaya po, muli, Ginoong Pangulo, ang aking pag-object doon po sa motion ng ating kagalang-galang at kaibigan, Senator Bato Dela Rosa, ay base po sa mga binanggit ko po ng mga reasons. Maraming salamat, Ginoong Pangulo.
Before the chair makes a ruling, Senator Bato.
Yes, Mr. President. I just would like to share this august body, the basis for my motion. According to Chief Justice Renato Pono in Francisco versus House of Representatives, a number of things can be done before the Senate is convened as an impeachment court. For example, the Senate, which has the primary jurisdiction over the case, can decide the question of whether the one-year ban has been violated or not. Likewise, the Senate can decide whether the complaint on its face has any legal basis.
Mr. President, if I may.
So as not to belabor the point, Chair would like to state the parliamentary status and make a ruling. Again, to reiterate, Senator Bato, after the end of his privileged speech, made a motion, but before the chair could act on that motion, he asked for the recognition of Senator Bato, who wanted to second the motion of Senator Bato at the end of his speech. Before the chair could act on that motion and recognize Senator Bato, Senator Ontiveros and Senator Villanueva signified their intention to speak. Senator Ontiveros made a motion. To suspend further consideration of the matter at hand so that we can proceed to take our oaths. And then Senator Marcos raised the point of order that there are too many pending motions on the floor and that we should dispose of them, as correctly pointed out by her. Senator Villanueva objected to the motion of Senator Bato. With the permission of Senator Villanueva, hindi ko po ituturing na objection yung inyong sinabi dahil ayon mismo sa inyo, hindi naman kayo tutol doon sa motion ni Senator Bato, kanya lamang. Gusto nyo at sa paniniwala nyo, pwede lamang ito magawa kapag tayo ay isang impeachment court na at hindi bilang isang senado. Ayon sa authority na kinokot ni Senator Bato, may opinion, may concurring opinion. Si dating Chief Justice Puno na pwedeng itong gawin ng Senado. Concurring and dissenting opinion siya sa pagkakaalala ko sa Francisco. With the permission of the gentleman on the floor, the chair is of the considered view that and takes well the position of Senator Villanueva. We will act on the motion of Senator Bato, but as an impeachment court.
Yes.
We cannot act on the motion of Senator Bato unless we take our oaths as members of the impeachment court. Therefore, once the impeachment court is after we take our oaths and we convene the impeachment court, Senator Bato can reiterate his motion, Senator Go can then second his motion, if at all, and we will proceed to dispose of such motion after we hear from everyone who wants to speak on the matter.
Mr. President, just to clarify your statement, Mr.
Senator
President.
Villanueva, before I make a ruling.
Yes, Mr. President, you were saying, Mr. President, because the way I look at it, you're saying, Mr. President, that in order for us to dispense with the motion of Senator Bato, we would have to convene?
We would have to convene the impeachment court, as you said earlier.
Yes, Mr. President, I thank you for that. But in order for us to convene again, Mr. President, and just for the information of our law students and those who wanted to learn from these proceedings, Mr. President, this representation made a statement yesterday that we cannot proceed with the convening of an impeachment court unless we issue notices, Mr. President. And I made mention about it because the minority leader's motion yesterday was to convene and at the same time talk about the calendar of activities, Mr. President. And so I would just like to put that on record, Mr. President, because we are not going to discuss the agenda of the, if we convene the impeachment court. Is that the case, Mr.
The
President?
matters to be discussed requiring notice included the schedule, proposed schedule of the
Yes.
impeachment complaint, which needed the presence of the parties. However,
Because if we can do it by ourselves, for example, Mr. President, just approving our rules on impeachment,
However-
issuing summons, we don't need to issue notices. Is that
there's-
correct, Mr. President?
However, there are certain matters that the court can do motu proprio,
Yes.
and it would perhaps include these matters, which is up for the consideration of the court once we convene. So
Thank
again,
you, Mr. President, thank you.
Senator Bato is recognized.
Thank you, Mr. President. I just would like to counter the statement of Senator Joel Villanueva, Mr. President. You know, as the good Senate President mentioned yesterday, the Senate dismissed the impeachment complaint against Ombudsman Gutierrez after she resigned without convening the impeachment court. Therefore, the Senate, without convening into impeachment court, is not prohibited from dismissing the impeachment case, Mr. President. It's very clear. When you say iba, iba nga kasi nag-resign. Pero still, the capacity or the legality of the action of the Senate not convened as an impeachment court was not questioned. So therefore, considering this case, I think we can do the same, Mr. President.
Mr. President, if I may, Mr. President, this is in reaction, Mr.
With
President.
the permission of the gentlemen who have the floor, Chair will suspend for a few minutes because you will most likely simply engage in a debate because clearly you both have different positions on the matter. Chair would like to make a ruling with the permission and indulgence of the gentleman who had the floor earlier. Again, to reiterate the parliamentary status. It is the opinion of Senator Villanueva that we can only act on the motion of Senator Bato if we convene if we constitute ourselves and convene as an impeachment court. It is the opinion of Senator Bato that we can act on the matter sitting as a Senate in plenary. While both are considered, while the chair considers both legal and possible and probable, the chair prefers that we convene as an impeachment court first before we act on the motion of Senator Bato, and after we approve the rules, that will be the first item in the agenda of the court after being seconded by Senator Go.
Point of clarification.
Yes, Majority Leader.
With the permission of Senator Bato, would that mean, Mr. President, that the motion pending right now would have to be reiterated before the impeachment trial court by the movant, Mr. President?
Yes, that is correct, Your Honor.
And
Given the position of the chair, Senator Bato.
Yeah, with the indulgence of the Senate President.
Yes, please.
May I respectfully request that before the ruling is made, or you have made the ruling already, so I therefore object momentarily your ruling because I have to consult my
For the last time, the
President.
chair will now state the parliamentary status. Senator Bato made a motion that Senator Go wanted to second. Senator Joel took the position that we should sit as an impeachment court before we can act on that motion. For the chair, the suggestion of Senator Villanueva is well taken, while recognizing also the position of Senator Bato, although the chair prefers the position of Senator Villanueva that we first convene as an impeachment court before acting on the motion. So the chair hereby rules that in order to act on the motion of Senator Bato, we should first convene as an impeachment court by taking, by this representation, presiding over the oath taking of the members of the Senate, where the first item in the agenda of the impeachment court, after we approve our rules, will be to act on the motion of Senator Bato, listen to the seconding speech of Senator Go, and perhaps the seconding speech also of Senator Padilla, or whomsoever would like to second the motion, allow the members to speak before dividing the House. Therefore, Chair will suspend session in order to allow the members to kindly don your robes, impeachment robes, so that the chair can subscribe the oath to the members of the impeachment court so that we can convene the impeachment court and do the things, the items rather, that the chair mentioned earlier. Senator Bato.
Mr. President, I think I got the point of the good minority leader. And I would like to expound this, Mr. President, that after we take oath, Mr. President, can we go back as a Senate, not as an impeachment court, para pagbigyan na makapagsalita yung aking mga kasamahan, si Senator Bungo at si Senator Robin Hood Padilla, not as an impeachment court, but as a Senate, Mr. President. Just reverting back our status after taking an oath.
Mr. President, may I make a suggestion?
Senator Allen is recognized.
Sir, konting patience po from someone na mas madalas makipag-away kaso sa ipagbati ang ating mga kasama. May I propose this? I disagree with Senator Bato in dismissing the case. I agree with him based on former Chief Justice Puno's statement. And naniniwala kasi ako pag jurisdiction, titignan muna natin sa body. Having said that, tama ang ruling ng Senate President that either or, which is better. The only reason I think that better yung impeachment court because we will take an oath of political neutrality. While there's no test for that, konsensya na natin lahat once we take our oath. May I suggest, because I think the konting disagreement between my two brothers, Brother Joel and Brother Robin, is may feeling na hindi natin pinapasalita yung iba. May feeling naman ng minority dahil mas konti sila ay sinusupil ang kanilang karapatan isulong ang isang constitutional duty. May feeling naman yung iba dito sa likod na bakit masusunod yung minority. But I think, Mr. President, when we convene as an impeachment court, am I correct? Senator Bongo and Senator Robin and anyone who wants to speak on the issue of dismissal or any other motion will be able to speak and can move that their statement also be reflected in our session after or tomorrow.
That is correct, Your Honor.
So that they don't have to repeat it twice. Because the problem, Senator Bato is not an attorney, but he's talking like an attorney. So Senator Batorney, my humble opinion is mas mabuting mag-oath at doon because the statement of Senator Bongo and Senator... Ako mismo, I wanna argue bakit hindi dismiss. If I argue it here now, then I will have to argue again in the impeachment court. But if we argue it in the impeachment court, then move that it also be in the records of the legislative session, then we have both of best worlds, if it's acceptable to you. Yeah? If it's acceptable to you, Brother Robin. Yeah? And to the minority leader. Thank you, Mr. President.
The point of Senator Cayetano, accepted by the members so mentioned, is well taken.